Ladies and gentlemen, welcome to the CIL eAcademy and our lecture by Sir Michael Wood on the topic, To what extent do the ILC's articles on international responsibility reflect existing international law? This session will run for about 60 minutes with a lecture by Sir Michael followed by a Q&A. Allow me to now pass you on to our moderator, the co-director of the eAcademy, Professor Patricia Galvão-Teles.
Yes, very good to see you all again today, and I want to give a very warm welcome to Sir Michael Woods, and we are extremely grateful to have him as part of the CIL eAcademy for a special lecture today on international responsibility. We have had yesterday, as you know, and we'll continue tomorrow, the lectures with Professor Pierre Baudot-Livinec, and today we'll have Sir Michael also speaking to you on international responsibility, and especially on whether the ILC draft articles are reflecting of existing international law. And he is the right person to do it. I'm sure you will agree with me after the lecture. He's one of the persons that has, I think, the widest and more varied and rich experience in international law. Not only he is a very dear colleague of Nilofer and myself at the International Law Commission, where he's also been a special rapporteur on the topic of identification of customary international law. We have already discussed the draft conclusions on customary international law that were adopted by the Commission under Sir Michael's guidance. And he, before being in the Commission, he was the principal legal advisor for the Foreign and Commonwealth Office of the UK between 1999 and 2006. He had served as an FCO lawyer for a long time before that, in a total of 35 years, if I can say that, just to let you know the breadth and the extent of his experience. And after leaving the Foreign Office, he has acted for many different governments before, in cases before the ICJ, the ITLAs, the European Court of Human Rights. I will not attempt even to describe the number of states that Sir Michael has worked for and the number of cases he has argued, not only on behalf of the UK, but also different other states. So he's really, the person that has an extremely rich experience. He's also, although you will certainly claim that he's not an academic, but he has published a lot on international law on many different issues, and you will see from his presentation today, and certainly from the discussion, that he is really the most able person to talk to you about the issue of international responsibility, as he would be in probably any other subject of international law. So Michael, a very warm welcome from Nilofer and myself. Sir Michael will do an initial presentation, and as we did in the past, we'll do a discussion afterwards. We encourage you again to keep your cameras on, do live questions if you want, but you can also send them through the chat, and I will moderate that afterwards. So Michael, the floor is yours, and we're really happy to have you with us today.
Well, thank you very much, Patricia, for those kind words of introduction. I'm very grateful to you and to Nilofer and to all the others in Singapore for organizing this eAcademy, which seems an excellent program, and for inviting me to talk. The subject that I chose is, to what extent do the ILC's articles on international responsibility reflect existing international law? And I propose to talk about two matters briefly, because I want to leave plenty of time for questions. So I'll only talk for about 30 minutes at the most. And the two matters are related. I think the first one is what's in the title: to what extent do these famous draft articles, these famous articles, I should say, reflect existing international law? And then a related question is whether they should be transformed into an international convention so that they would have the status of a treaty, whether there would be advantages in doing that. A matter on which I think Patricia and I have different views, at least I hope so. Now, on the first issue, when I look at the title I wrote, I see that it's very broad. Firstly, it talks about the articles on international responsibility. So that's at least 3 sets of articles. There's the articles on state responsibility, the articles on the responsibility of international organizations, and the articles on diplomatic protection, and possibly even the articles on liability for lawful acts. But I'm going to focus on the articles on state responsibility. I think the questions are quite different when one comes to the articles on international organizations' responsibility. A second thing I noticed, and really only noticed this morning when I looked at the title, it doesn't refer to customary international law. So the question is wider than whether these articles reflect existing customary international law. And the question occurred to me whether they might reflect general principles of law recognized by civilized nations. This is the third source of international law that we see in the ICJ statute. I think probably in the early days of state responsibility, at the time of the Chorza case, for example, people may have had in mind to some extent general principles of law, which had been found in the decisions of arbitral tribunals and the like, which perhaps lie at the origin of the international law of state responsibility. So there is a real question in my mind, how far these draft articles reflect general principles of law as well as customary international law. I'm not going to go into that in any detail because I think it's a really difficult question. I would say that the early cases of the Permanent Court on responsibility are dealing with customary international law. They refer to case law, they refer to, but there are parts of the law of state responsibility that may well reflect general principles of law. For example, the article on force majeure has a couple of paragraphs saying force majeure is a general principle of law. So even the ILC had in mind general principles of law as well as customary international law. That gives rise to the very interesting question whether the general principles of law continue to exist even though there is now customary international law on the subject. So I'm not going to say any more about this, but I think there's a real issue that would be worth exploring. Another observation at the beginning is that surprisingly little has been written about the extent to which the articles on state responsibility, for example, reflect existing international law, reflect customary international law. If you look in the books, if you look at Crawford's big book on the subject, if you look at the ILC commentaries, there's a little bit about the subject where it says, for example, that the rules on peremptory norms of general international law aren't customary international law. That was the view in 2001, but they may have become customary international law. But very little's been written about it. That's different from cases where there's been a codification in the form of a treaty. If you look at the Vienna Convention on the Law of Treaties, any book on the subject, it has a section dealing with how far is the Vienna Convention a reflection of customary international law. Ian Sinclair's book on the Vienna Convention has a very useful chapter on the subject. All the article by article commentaries have a section for each article saying whether or not and how far it reflects customary international law. But nobody seems to have done that with the law of state responsibility. Indeed, it almost seems to be assumed that the articles on state responsibility are customary international law. That's a very big assumption, and not one that I think is in any way justified. As you may know, the presidents of the International Court of Justice come and talk to the International Law Commission every now and then. And Judge Abraham, when he came to talk to us as president, he said, whether the text on state responsibility is part of custom, although the court has had occasion to speak on that point concerning individual articles, it has not taken a position in general and avoided doing so where there was any doubt. And President Higgins similarly said it would not be correct to say that the court regards the totality of the draft articles on responsibility as customary international law. So there is a real question. How far do these draft articles reflect customary international law? If one looks at the judgments of the court, more and more references are made to the draft articles, but they're often made to the same draft articles. And there are huge parts of the draft which have not been considered by the International Court of Justice. So I think there is a very interesting article to be written, and I'm not going to write it now, on this subject of to what extent do the articles on state responsibility reflect customary international law. And I just mention a few of the provisions which I think are really quite, or where there is a real question, how far they reflect customary international law. I've already mentioned the question of serious breaches of obligations under peremptory norms of general international law, Articles 40 and 41, where the Commission itself in 2001 said that, to some extent anyway, these did not represent customary international law, but were progressive development. So the question arises, is that still the case 20 years later? Well, that's a very difficult question and not one I'm going to answer. It's a very practical question. It's one that courts from time to time have to face. But there are other provisions, and the one I'd like to speak about first is the Article 16 on aid or assistance in the commission of an internationally wrongful act. This provision is the one that I think foreign ministries look at more than any other. I can recall when I was in the Foreign Office, we were constantly looking at this provision to see that if what we were doing to assist another country to do something would be a breach of our obligation not to aid or assist in the commission of an internationally wrongful act. The absolutely clear set of circumstances where this arises is in connection with the use of force. For example, if the United Kingdom allows the United States to take off from air bases in the United Kingdom or in Diego Garcia, if I can mention that, to conduct military operations. And if those military operations are unlawful, have we aided and assisting in the conduct of an internationally unlawful act? It's a real question. I think states need to look very carefully at what they are assisting, what they're allowing to happen from their territory. Another case arose in litigation, I think, which consisted of the building of a dam in Turkey, if I can mention that, where there was a real question whether the building of that dam violated, whether in building the dam or allowing that dam to be built, Turkey was violating its obligations under international environmental law or human rights law. And whether the United Kingdom, by allowing its nationals to finance that dam and not doing due diligence with themselves in breach of Article 16, was a real issue that arose, I think, in the courts. So the actual wording of Article 16 is not entirely clear. It's a provision that has to be read with the commentary, and there are conditions in the commentary to Article 16 which are not actually in the article, which has led Giorgio Gaia, for example, to question whether those conditions that are in the commentary are actually part of the article or not, when they're not even referred to in the article. I would say they are, but nevertheless there's an issue there. So there is a big question as to the extent to which Article 16, this key article on aid or assistance, is part of customary international law, or even a general principle of law, I guess. Another provision which is, in my view, controversial, or which should, in my view, be controversial, is Article 25 on necessity. You may remember that this is a very curious provision that appears to be a let-out clause for states. It's very easy to say, well, something's necessary, so it's lawful. Of course, it's quite narrowly drafted, but precisely what it means is not entirely clear. It came about, in my view, in a very unfortunate way. The International Law Commission, in its first reading, included this provision when it was really quite questionable. The International Court of Justice then, in the Gapchikova case, approved of the provision and applied it, even though it was only a first reading provision. And so the International Law Commission, on second reading, didn't have much choice but to endorse what it had done on first reading, even though there were still severe doubts about it. So that's a provision which I think, at least in terms, is worth, in its actual precise terms, is worth looking at to see whether it reflects customary international law. The whole area of countermeasures was, of course, very controversial when the provisions were adopted. There are quite large aspects of the countermeasures provisions which I think it would be difficult to say were necessarily customary international law, particularly the very curious Article 54 about measures taken by states other than the injured state. This, if you recall, is a pretty incomprehensible article that raises a really important issue, and nobody knows what it means. So so to what extent does it reflect customary international law? Those are just a few examples of the difficulties which I see. As I said, the judges of the court have warned that we have to look very carefully. They have not decided that the text as a whole is customary international law. They have emphasized that you need to look case by case, provision by provision, to see to what extent it does reflect customary international law or general principles of law. And there I would just recall, you may have already looked at this, what the International Law Commission said about its own output when it was looking at the question of identification of customary international law. I apologize if you've already looked at this, but undoubtedly it's the case that the output of the Commission is often given very great weight, including by the International Court of Justice. In my view, too much weight, quite often. But when we had to decide what the exact status was of the output of the Commission, was it the writings of highly qualified publicists, collective writings? Was it something else? The Commission really couldn't decide. And in the end, what it did was to just not even mention its own output, in the conclusions on customary international law, but to include a paragraph in the introduction to the part 5 on specific materials, which simply said that the conclusions or the output of the International Law Commission's work was important, but then they added some important qualifications. It says that the weight to be given to the Commission's determinations depends on various factors, including the sources relied upon by the Commission. That, I think, means how thorough was the Commission, how much practice did it have to go on. The stage reached in its work, that's waving a finger at the International Court of Justice, saying you really shouldn't pay too much attention to what's only a first reading text. Even less should you pay attention to what a special rapporteur has written in his or her reports. Even less should you pay attention to what members of the Commission have said in their speeches in the Commission, something that the Swiss Federal Tribunal did in trumps, if I can put it that way, in a case involving the possible immunity of a defense minister, of the Algerian defense minister. An awful decision where they said, well, members of the Commission said this, so it's the law. I mean, that's no way of doing it. And then the Commission said it depended on various factors, above all, upon states' reception of its output. And I think that must be right. You have to look at what states have said about the Commission's output in order to determine what its weight is in terms of customary international law. So the debates in the Sixth Committee are very important. And one shouldn't take the view, which some do, some states have done, that the Commission is becoming a legislature, which is not supposed to be, because the Commission merely puts forward proposals, and it's the reaction of states that really counts. So if states are silent, or if states welcome something, that's important. States need to speak up and say they don't like something if they really don't like it. And that's what they did in a fairly recent outcome, which was the outcome on protection of persons in the event of disasters. So I think that in order to determine the extent to which the articles on state responsibility are customary international law, a lot of work is needed. You have to look at what states said in 2001, but also every 3 years since then when there have been debates. You have to look at what courts have said, and of course there is now a large amount of case law on the subject, but usually focusing on the same few articles, so it's not clear that the courts have given guidance across the board. You might also want to look at what writers have said, but actually writers have said very little. They tend to just assume that if it's in the articles on state responsibility, it is customary international law. And I think that's a very lazy assumption, a very lazy way of approaching the question. So that really is what I want to say about that. Now, related to this question is whether the law would be clearer, whether it would be good for international law, and I think that's the test, if these draft articles, these articles were converted into a convention by the holding of a diplomatic conference, or by the Sixth Committee of the General Assembly adopting them, as it has done with some other conventions. I think the arguments are quite finely balanced, and the views remain divided among states. And my reading of the latest debate, which was in 2019, is that they're still divided, and that the arguments against turning it into a convention are perhaps gaining ground, or being noted by more states. And just to give an example of how nuanced it is, I'd like to quote what Portugal and the United Kingdom each said in 2019 when they were asked to put comments in writing. Portugal said that they acknowledged and understood the concerns expressed by some states about the potential uncertainty of convening a diplomatic conference, about the possible negative impact that a negotiating process might have on the text of the draft articles. The fear, of course, is that they will unravel, that if states start trying to amend them, they'll try to amend some of them, and some of the most delicate compromises will unravel. And then Portugal went on to say, however, we must bear in mind that the International Law Commission is not a legislative body. States are. That's a very clear and accurate statement in my view. And so it says the articles are not untouchable, states can negotiate them if they want to, and that the dangers can be minimized in some ways. So quite a nuanced position from Portugal most recently. But the United Kingdom, which has been one of the most outspoken of those who say that it would be dangerous and it would be disruptive of the law, which is doing very well so far and which is developing with case law and with practice, to have a conference on this subject. United Kingdom, Australia, James Crawford himself have been taking that line, as have others. But in 2019, the United Kingdom said that we'd highlighted the risks of pressing ahead towards a convention. It has the potential to disturb the balance that was struck when the articles were drafted, risks provoking divergences. But then it says, the United Kingdom remains very mindful of these risks, but is open to engaging in a sixth committee discussion and consideration of options for progressing the articles, including the possibility at an appropriate time of negotiations towards the convention. So there you have the two extremes, if you like, Portugal and the United Kingdom, both showing understanding for each other's position. And that, I think, is very interesting and shows that more dialogue on this subject is needed. My own view, well, firstly, the history is that James Crawford recommended a compromise. There were two views in the Commission, those who wanted the Commission to recommend a convention, those who wanted the Commission to simply recommend that the General Assembly take note and commend the articles to states for their use, whatever use they wanted to make of them. Crawford proposed a compromise, which was that the Commission should take note of the articles, commend them to states, but also keep under consideration the possibility of moving towards a convention at a later stage. And that's in fact what the Commission did the General Assembly did in 2001. But as you know, every 3 years since then, the item has come up, has been discussed, and the position has remained essentially the same. There's been no progress towards moving towards a convention. Has anything changed since 2001? Well, I think that one thing has changed, and that is that these articles on state responsibility have proven to be very useful in practice. They are referred to whenever necessary by courts, by governments, by writers. They are the starting point anyway for any consideration of responsibility under international law. And they're building up, they're doing what those who thought that taking note was the better way to go had hoped would happen. They're becoming more solid, they're becoming gaining more authority. I think that they are one of the great successes, obviously, of the Commission. The arguments in favor of a convention are perhaps it's partly the view that states take towards international law generally. Some states still only think it's good law or clear law if it's in a treaty, if it's in a convention. Particularly, their courts may be very reluctant to look at customary international law, where they are willing to look at a convention, even if a convention hasn't yet entered into force. They'll still give it higher authority than customary international law, which they can argue about forever. So there are arguments in terms of greater authority for a convention. There is, of course, the risk that a convention will unravel, that a convention will not be ratified by many states. A convention as general as one on state responsibility may receive very few ratifications, just as we've seen that the Convention on State Immunity has so far received very few ratifications, and that can lead to arguments that it has weakened the authority, its decodification, if you like. So there are arguments against. Now, one interesting argument is one put forward by Professor Taladi, a member of the Commission. He argued that not turning it into a convention was undemocratic, if you like, was allowing the International Law Commission to have the last word on international law. It's states who are the legislature. So by not converting these articles into a convention, states are abdicating their role as the legislature, allowing the International Law Commission to have the last word. And while that may be not too harmful in this context, it's very bad in principle. So this is an argument generally for taking the work of the International Law Commission, not saying it's the last word. Now, I can understand that argument, but I think it's wrong in some ways, because the International Law Commission doesn't have the last word. On, for example, the topic where I was Special Rapporteur, the identification of customary international law, yes, it was put before the Sixth Committee. Yes, there was no opportunity for the Sixth Committee, because it chose not to, I suppose, to look in detail at the text, to start amending the text, and I'm very glad they didn't. But that was the choice of states. And states did have an opportunity to comment, and states did comment on the conclusions on customary international law, for example. And their comments are very important. And some of them, not all of them were positive. A lot of them were, but some of them weren't. So they have to be taken into account. So states do have an opportunity, and they've had ample opportunity in the case of the state responsibility articles to have their input, even though they've not had a negotiation at which the articles have been subject to amendment. So I think I've spent 30 minutes, and I'll leave the rest of the time for questions, if I could. So I think Patricia is going to guide me through the questions and perhaps answer them too. Thank you.
Thank you so much, Michael. Of course, the temptation to answer some of the questions is big from my side, but today you're the one who are on the spot, so I can resist that temptation. No, thank you so much for a brilliant presentation, very clear, straight to the point, as we know you. It's of course, I think this is an issue that is crucial to the question of state responsibility, international responsibility in general, but also it evokes many of the questions that we discussed also in the module that I lectured on international lawmaking, because it does touch on the role of the Commission, the role of states, the role of the different sources, the interaction between customary international law and other sources, and the making of international law. So thank you so much for that very clear and very rich presentation, where I think participants can get the feel from how these questions are viewed from somebody who has an experience, enormous experience as a government lawyer, but also at the same time as a member of the Commission, and at the same time as a representative for other states before international courts and tribunals. So this is the kind of analysis that one does when one is faced with a question of responsibility, and also how to argue a question of responsibility when you have the articles that are not yet a convention, and what weight do you give to the articles. And I see that there's, I think there's already a question from Evgenia and also from Ankit. So we will have live questions, which I think Sir Michael appreciates very much. Yep. And I do have also, I think, a background question that comes to my mind when you are presenting, on the one hand, the tendency that states and academics and others have when looking at the articles as customary international law, and you see that a bit as a negative tendency. And my question is also if that tendency isn't precisely because they have not yet been turned into a convention. And so the way you have it to turn them from soft law into hard law is precisely to take them as a whole as a convention. So that's also a bit of the dilemma that we have when we discuss these issues, which is something that we have, as you mentioned, discussed a lot, not only as representatives of our own governments, and the positions of Portugal and UK were quoted for a purpose, but also as colleagues in the Commission and in academic debate. So I'm going to give the floor to Evgenia and then to Ankit.
Sir Michael, thank you very much for the lecture. And my question is more general. It concerns how to work with the ILC documents, ILC reports and studies. So if I understood you correctly, when working with the articles on state responsibility, the first thing is not to take the entire text for custom. Then you take the specific article, and then is a rigorous lawyer then expected to look at the same documents that the ILC looked at to find out whether it is custom or not? So what is the exercise for confirming whether an ILC conclusion or article or finding is customary or not? Where does this exercise end if there are so many assumptions and qualifications? It just sounded a little bit like, so the conclusions of the ILC are tentative, and in order to clear one's conscience as to whether something is custom or not, the person in question who has to read the same sources that the Commission relied upon.
Thank you. Well, that's, of course, a very good question, a very big question. Former President Tomka of the court gave a kind of answer in his very interesting speech on how the ICJ discovers customary international law. He says, well, we often take shortcuts. We often find a text, and it might be an ILC text, and we look at it, and if we think it's sensible, we say that's customary international law. We can't possibly start looking at the whole, start from scratch. We have to accept that the ILC has done a good job and that it has looked at all the sources and looked at it very carefully and taken into account comments from states and all this very thorough procedure that the International Law Commission engages in. So he tended to suggest that you can just, the ICJ inevitably takes a shortcut, and if it likes a provision the ILC's come up with and thinks it would be good customary international law, it says it's customary international law. And that's understandable to some degree. Often the matter will have been argued by the parties in some depth, so the court will have had not just the text of the ILC, but have had argument about it. But I do think that you can't just automatically assume that what the ILC has written is customary international law. Firstly, it may not have intended it to be customary international law. And often within the ILC, there are different views. Some people may think a provision is customary international law. Some may think it's not. A good example at present could be the very controversial topic of the immunity of state officials from foreign criminal jurisdiction, where there's the famous draft Article 7. Some might say that is customary international law. Some might say it's not. I think it's very important on that particular point that the ILC comes to a clear conclusion. That could be very helpful. But often they don't, and often they leave it open. And with the articles on state responsibility, there are one or two places where the ILC says very clearly that it's progressive development. In other words, it's not existing international law. It does that for the peremptory norms provisions, as I mentioned. But most of the time, it doesn't express a view. It just says what materials it's looked at. Of course, that's now 20 years ago. So in doing your own decision, as it were, taking your own decision, you have to look at everything that's happened since then. You have to look at the reaction of states. You have to look at the case law, and there, helpfully for state responsibility, the UN has published abstracts from the cases every few years, and there are hundreds of cases. So it's easy, relatively easy, to find the international case law. That doesn't include the national case law, which may also be important and useful. So you have to look at that. You have to look at what writers have written about it. So I think looking at the subsidiary means for the determination of rules of international law in 38(1)(d) of the statute, that can be helpful. They're not determinative, but they're helpful. So you do need to work reasonably hard, I think, perhaps a bit harder than Judge Tomka indicated. And I think that the ILC's text should be a starting point. It shouldn't be more than that. I would mention one other thing that occurred to me about these articles on state responsibility. There is actually no commentary on these articles that I'm aware of. The Vienna Convention on the Law of Treaties, we have 3 or 4 leading commentaries, and we can go article by article and see what that helps, sets out the practice. The Convention on the Law on Torture, the UN Convention on Torture, there's a detailed article by article commentary, which is really useful. So far as I know, no one's actually done that with the articles on state responsibility. Perhaps it's because they're not a convention. But I would see merit, perhaps you should tell Pierre Baudot to do this, to organize, he could write it in a few months, or get a group of people to write an article by article commentary on the articles on state responsibility. I think that would be a really useful resource that would help you with your good question, how do we set about this? The first place you look is a commentary, and there isn't one. There is, of course, James Crawford's 600 or 700 page book on the subject, which is really useful. But of course, it's his own view, just his own view, and it doesn't do it article by article. To a degree it does, but it doesn't really, it's not as useful as an article by article commentary, in my view. Thank you for the question.
Thank you so much. I will ask then Ankit to take the opportunity to ask his question. Ankit, you have the floor.
Yeah, sorry, I lost the connection. Am I audible?
Yes?
Yes.
Yeah, well, so good afternoon. Thank you very much for the lecture. In fact, your tales were shared by me with my professor, Professor Gudmundur Eriksson of Iceland. So he
Very
said,
good.
I should say a good hello to you. I have
Thank you.
two questions for you. My first question is on the Article 25 of the ASR that you'd highlighted on necessity. So, sir, would you not see someone applying the ambit of necessity using the lens of R2P and this Kofi Annan principle, which a country can use as in order to say that, well, you can use necessity, and you can say that, and borrowing from the words of the commentary uh, of the articles, it says that if it is a grave and imminent peril, then you can go ahead with necessity, or that qualifies the test of necessity. That's question or sort of comment one. My second is regarding the what you just highlighted in the previous answer you were giving regarding the uh, laws on immunity and the writing that you've done with Andrew Sanger for the Cambridge Handbook. So, and with special, I'm not sure if you'll be able to talk about this, but with reference to the Enrica Lexi case and how immunity was applied by the Italians in order to rescue the Marines. So, could you highlight that if possible? Yeah, that's all.
Yes.
Thank you.
Well, thank you for those questions, and my best wishes to Gudmundur. I was thinking about him only the other day as I walked around London, wondering how he was doing if he's in Delhi. And
so he's back home at Reykjavik, but I'll convey your regards.
Anyway, give him my regards. He's a very good colleague. We sat on a committee of 2 people at the Law of the Sea conference to deal with commas in the Law of the Sea Convention. We produced a 10-page report on commas in the convention and how to get them right, which was then adopted. So I had very good cooperation with him. But necessity, firstly, my view is that it should be such an exceptional thing that it should not have appeared in the draft, in the articles. I would have preferred the articles without necessity, because it really is an exception. It's so capable of abuse. It's so subjective. It's so easy for states to say, oh, we have a terrible necessity and we're going to do this. And that's just self-determination. No, it's not self-determination. States can say so many things. And I think it's dangerous to have even put it in the text, which isn't to say that there may not be exceptional circumstances where a necessity may apply. Now, you raised the R2P specifically. I mean, that's a very big question. The British government has long held the view that in exceptional circumstances, there is a right to intervene where there's an overwhelming humanitarian necessity to do so. But that view of the British government, I have to say, has not had much traction. It was rejected by the non-aligned movement in the General Assembly, which is quite a lot of states to reject something. So I think it's controversial. I think if it's based on anything, you're right, it's based on some notion of necessity. But whether it, it's a big question you've asked. So far as the Enrica Lexi case is concerned, well, I won't say anything because I don't like talking about cases that I've been involved in. Only to say this, it did raise the very interesting question that also was raised in the International Law Commission about the extent to which there's a territorial tort exception or territorial criminal offense exception. Of course, this was a rather special circumstance because the shooting went from one ship to an Indian ship. So did the territorial tort exception apply? If it applied, did it override the immunity of armed service personnel, if you assume they were armed service personnel on service, which certainly I think they were. But it's an example, and it's very interesting if you read the decision, obviously, of where the law of state responsibility is very important, and where the work of the International Law Commission is very important in how it's been interpreted by the court, by the tribunal. I have to say on that subject, since I was involved in the Enrique Lexi case, I did not take part in the discussion in the International Law Commission on the territorial tort exception. So I stayed silent in the drafting committee, and I stayed silent in the plenary on that, because I don't think it's right, if you're involved in a case, to take a position in the International Law Commission. It's one of the problems of wearing two hats. Thank you. So,
Patricia, you are muted.
Sorry, I'm accessing my chat because I saw we have a question in the chat from Robert. I think it's a question prompted by the fact that, Michael, you mentioned that there's no commentary to the articles on state responsibility like we have on the law of the treaties or even the Vienna Conventions on diplomatic relations and consular relations, where there are also very useful commentaries. The question is, may I please confirm whether the 2008, I suppose it's 2001, commentary on the draft ILC articles on state responsibility that appear in the websites, the ones that have been produced by the Commission itself, has not been recognized as authoritative. I understand that this document purports to have been adopted by the ILC. Confirmation on this point would be much appreciated. I think the question is about whether that commentary is not enough from the comments that you made.
Thank you. And yes, that's right. The 2008, I think, comes from the publication date on the document itself.
Yeah.
Okay. Well, obviously, that's a very important part of the output, because the articles need to be read with the Commission's commentary. But the Commission's commentary is what it is. It's concise, and it was deliberately concise on this occasion by comparison with what Roberto Argo had written, which really was a commentary. I mean, he did huge detailed commentaries on some of the articles, the ones he was responsible for. But the commentary of the Commission, I think, is an important part of the overall output, which, by the way, would kind of get lost if it was converted into a convention, because then the commentary is no longer published with it, and what's the relationship between the commentary and a convention? It's more distant than between the commentary and the articles. So I don't think it's a substitute for an up-to-date book that goes article by article and says, this is what the Commission did, this is the extent to which it reflects customary international law in our view, this is the extent to which it's been dealt with in cases since then, and here's the state practice. Something that's considerably more detailed, as well as being 20 years more up to date than the Commission's commentary. And the Commission's commentary, of course, they can be very valuable, but they're also a compromise, you know, they're negotiated within the Commission. Thank you, Robert.
Thank you so much. I don't see any more questions in the chat or hands raised, but perhaps there's still one last question. We have a few minutes still.
Well, you had a question, Patricia, didn't you? Or a
yes,
comment?
I did. My question was whether the fact that precisely because the articles were not yet turned in the convention that induced that temptation to assume that tendency, as you mentioned, to assume that all articles were customary international law, in a way, to use Tomka's words, shortcut also to from soft law to hard law, in a way. So perhaps you want to use the remaining time to comment on that.
Well, I think that's a very interesting question, and it occurred to me as well. The very fact that it hasn't been turned into a convention makes it more likely that the whole thing will be regarded indifferently as without distinguishing between different provisions, as customary international law. The temptation is there. Somehow, if it was converted into a convention, people might look more carefully at particular provisions. They'd look at what happened at the conference or in the Sixth Committee when the convention was adopted. I don't know why that is. There's no real rational explanation, but somehow you may be right. The tendency to just say, well, it's all customary international law arises because it's all we've got. We've not got a treaty. We've only got customary international law in this field of responsibility, except where there are particular treaties in particular narrow fields, perhaps. But the whole of international responsibility is customary international law at present. Therefore, one might take a sweeping view of the basic text. Of course, people do look more carefully, perhaps, at the text about the responsibility of international organizations, which I mentioned at the beginning. And there the Commission were quite clear in the introductory note to its articles on international organizations. It says, even where the language is exactly the same as in the case of state responsibility, these articles may be less likely to be to reflect customary international law because there is less practice in this field. I'm putting it rather crudely, but essentially it said that, which is also interesting. It's almost the Commission itself saying our ones on state responsibility, well, that's customary international law. The question really is, are these new ones on international organizations customary international law? It's an interesting distinction, and it's not a distinction that I think courts have really picked up on. As some people feared, particularly people working for international organizations, and as the courts have tended to just look at the provisions on international organizations' responsibility and say these are also customary international law. There's a great strength. I mean, as I half mentioned earlier, I think people, courts, writers, give too much weight often to the work of the International Law Commission. And that's why I've described it as a dangerous place. It's a dangerous place because its work is given too much authority. That's not the fault of the Commission. It's the fault of those who give it too much authority, be they courts or states or writers. But it does mean that those of us on the Commission should, in my view, be extremely cautious and extremely careful with what we do, because what we do, whether it's good or bad, whether it's based on thorough work or not, runs the risk of being seen as authoritative, as reflecting customary international law, even when it shouldn't. So that's why I say the Commission is a dangerous place. It's people bow down to it too much, in my view. Would you agree with that, Patricia?
Well, I agree that I enjoy working with you in a dangerous place. That's certainly the case. But I don't want to take time because there's one last question from Mary Chong in the chat. And perhaps if you allow us, we're just finishing now. But She is asking, and I think you may know her because she was in the International Law Commission seminar, if I'm not mistaken. If there's time, I'd like to ask Sir Michael if he's of the view that the draft articles are perhaps more conclusive as regards what is not customary international law, for example, the notion of collective countermeasures, if they are more conclusive of what is not customary international law.
Well, it's a very general question, but I think, as I said, there are one or two places where the Commission itself made it clear that this was not existing international law, but was progressive development. However, that was 20 years ago, and that may have changed since then in some respects. So you can't take it for granted that what the Commission said 20 years ago is still the position. It may have become customary international law as a result of practice, etc. But I think that for the rest, the Commission was silent as to its status. So in a sense, it's right to say it's clearer what isn't customary international law than what is. And maybe that's a general proposition as well. I've not thought about it before. But it's often easier to say something isn't customary international law than to say that it is. That's worth also a study, I think. Thank you.
Thank you so much, Michael. I think we have exhausted our time, but of course not the discussion. And you just gave us two excellent suggestions on what things should be continued to look at. And I think in particular, the idea of having a commentary, not the one done by the Commission, but an updated commentary now that the articles are going to turn 20 next year. That would be, I think, an excellent suggestion for a symposium and a book, and perhaps even a full commentary as you were proposing. So thank you so much for your time and for your excellent presentation and for sharing all your insights. I'm sure the participants have learned a lot on how to look at these questions from an insider's view, how these things work in practice and the difficulties in assessing the status of a document, and also some questions about policy making, about international lawmaking, as we mentioned before. So thanks again, Michael, on behalf of the CIL eAcademy, in particular of Nilofer and myself. And we look forward to seeing you soon, hopefully in Geneva in the spring, and if not, in the virtual world. So thank you so much, Michael. We really appreciate it. And
Thank
we
you very
can,
much,
I think,
Patricia.
give you a virtual
Thank you to everybody.
applause.
Well, I give you an applause too. Thank you very much.